Hi, I'm Anna Denton-Jones of Refreshing Law, and I want to look today at a number of issues that arise around giving of notice. Now, notice is going to be determined by one of two things. We've either got the statutory minimum notice, it's generally 1 week for every year served up to a maximum of 12, or the contractual position where the employer may have been more generous than that statutory minimum procedure. But the question that I'm often asked is about the difference between somebody working out their notice and making a payment in lieu of notice. Now, if, for example, we gave somebody notice that their employment would come to an end in the middle of March and they work that out, then their employment is going to end in the middle of March. However, if we decide to make a payment in lieu of that notice period, it's very much as the sort of name says on the tin, really. Instead of them working out that notice period, we're actually going to bring their employment to an end now in February, and we're going to make a payment instead of them having to work out that notice. So their employment comes to an end earlier, which may have advantages to the employer in terms of holiday accruals going to stop now, for example. We're going to make a payment instead of them working out their notice period. That often confuses people, and it's really important to put in letters what's happening. And I sometimes see letters that are a bit misleading and maybe talk about paying somebody up to the middle of March, even though their employment's going to end now, and that can be very confusing. So I think it's important to state when the employment ends, and that would be now in February, and that a payment in lieu of notice is going to be made. Indeed, I've had cases where perhaps there's been a question mark over when the effective date of termination was in relation to whether or not somebody's qualified to bring an unfair dismissal claim. So it's very important to specify in your letter exactly what is happening and not use misleading language around it. Now, another question that often comes up is we've given notice, one side's given notice to the other, and we now want to change that position. A bit like changing contracts of employment, you can't unilaterally as an employer say, we gave you notice, well, now we're going to change that position and we perhaps want you to, work on a bit longer or something. You can't unilaterally do that. What you can do, of course, is reach agreement with an individual. So somebody might only be too happy to stay on a bit longer. But what I would do in that circumstance is have a letter to them setting out what it is you're asking them to do and actually get them to sign acceptance of that and agree to do it. Of course, it can work the other way round, where as an employer you're being asked to cut a notice period short and perhaps not make somebody work out their full notice. You may agree that that's a sensible thing to do. There would be advantages of obviously having to pay the person less, because at the point that they go early, you stop paying them. They stop accruing holidays. You sort of bring everything forward. But you want to make it clear in writing exactly what is happening, and that although, for example, you might be waiving notice, what would happen, for example, with somebody's restrictive covenants and the fact that you still want them to be binding. I know it can be worrying sometimes if somebody's given out their notice. For example, you may run your payroll 3/4 of the way through the month, and their notice period might take them up to the end of the month, and you might be concerned that at the point that you pay them, you might not see them again, and that they may effectively let you down for the last week or so of the month. In that situation, if you look at your contracts, you've probably said something like that you'll pay people in equal monthly instalments, so you couldn't just not pay them yet for that final week, because that would put you perhaps in breach of contract, might mean that you then find your restrictive covenants have fallen away, etc. But it might be worth looking at something like the holiday that somebody has got. If they did do the naughty on you and not come in, would you be able to deduct for that overpayment that in effect you've made from holiday pay that you would otherwise have to pay in lieu at the end of the employment relationship. So it might be worth having a little look at that. Something that's always worth remembering is that when you give notice, in terms of counting when the notice starts, it's not the date on which you give the notice. So let's say I write to you today on the 12th of February. I start counting in terms of your 1 week's notice from the 13th of February tomorrow for a week rather than from today's date. So it's worth just remembering that. It's also worth remembering that in terms of unfair dismissal and the effective date of termination, that somebody can add their statutory notice period to their length of service to maybe get themselves across the line into bringing an unfair dismissal complaint. So you've always got to be careful terminating somebody's employment very close to them getting to the 2-year mark, because that 1 week's notice could tip them over into unfair dismissal territory. So again, be careful of that. There is always the possibility that somebody says they're handing in their notice in the sort of heat of the moment in an argument. Maybe there's a bit of a blow up with their manager, and the next day they've calmed down and they say, oh, I didn't mean to resign in that conversation. I didn't mean to tell you where to stick your job, sort of thing. There is case law on that, and an employee is entitled to calm down, and you are expected to take them back in that situation. And let it all blow over. So just be aware of that one as well. If anyone's got any questions, please do email me. It's adenton@refreshinglawltd.co.uk. Thank you very much.